Hey everybody, welcome back to the Court of Random Opinion. My name is Lauren Neidigh. We have a quick live stream this afternoon. There's an update on the docket. Justin Baldoni and the Wayfair parties have responded to Leslie Sloane's motion to compel, which she filed the other night. This isn't too long of a letter, so it won't take too long to get through. Let me give people just a second here to filter in, and then we'll start reading. We'll come out at 1 o'clock. Regarding Blake Lively's appearance on Late Night with Seth Meyers last night. I did put out a quick little recap, but I hadn't actually seen the clip yet last night when I did the video. So this one has the short clip of what she said in regards to this legal saga, as well as, my kind of response to it, and then some voices of other survivors who have spoken up about the situation, who don't think it's okay for her to be exploiting a false Me Too claim the way that she certainly seems to be. So that's coming out at 1 o'clock. So you should have Donna Bowling on your podcast. Love her. Yeah, I mean, I love Donna, but I have a hard time scheduling things because I just pop in on my breaks from work. So that's why it's so difficult to schedule with other creators and try to work things out. But, hopefully we can do that sometime because she's great. Yeah. All right. Let me pull this up. I don't know if anyone else is streaming right now, but I'll set the customization if they are. One sec. I'm just talking to myself. We got. Okay. All right, cool. Okay, let's get into it. Dear Judge Lyman, as counsel for Wayfair, Justin Baldoni, Jamie Heath, Steve Sarowitz, and we know the rest, we write in opposition to the motion by Leslie Sloane and Vision PR to compel certain discovery from the Wayfair parties. The Sloane parties have noticed the claims against them. So remember, Leslie Sloane in her motion to compel is basically saying, like, well, we don't know what we're really being accused of, or we don't know what they're talking about. So yeah, that's kind of the gist of a lot of her letter from the other night. But anyways, the false premise of the Sloane party's motion is that they purportedly lack notice of the Wayfair party's claims against them. However, the Wayfair party's amended complaint alleges that the Sloane parties made statements to third parties, including the New York Times, to the effect that Baldoni is a sexual predator who sexually assaulted Lively, and that Baldoni retaliated against Lively and others for reporting the alleged sexual misconduct, including by propagating false and misleading narratives about Lively for the purpose of damaging her image and reputation. And I want to point out here, guys, people will argue, well, she didn't say that he sexually assaulted her or whatever. Yes, she did. If you say that someone is doing non-consensual touching, kissing, lingering, or whatever, that is assault. So yes, she has in fact accused him of that. And we have already seen in the raw footage that was released that no sexual assault took place in that instance when she did claim that it happened. All right. The amended complaint alleges that the Sloane parties made... Did we just read that? Yeah, we did. No. Okay. Alleges that the Sloane parties made further false statements in response to media inquiries concerning Lively's wrongful accumulation of power over the production, how she did so, for example, false accusations of sexual misconduct, and the resulting turmoil. Specifically, the Sloane party stated to the Daily Mail that reports of a power struggle on set were 1,000% untrue. Your info is totally off. You have it all wrong. Your reporters are so wrong. Instead, the Sloane party seeded false information to cast Baldoni, rather than Lively, in a false light. The whole cast doesn't like Justin, nothing to do with Blake. They, the Wayfair parties, are panicking as the whole cast hates him, Baldoni. And then they're citing the paragraph there. Can you guys read this okay? Yes, it was just added to the docket. The Sloane parties falsely and gratuitously allege that Melissa Nathan surreptitiously listened, then reading the footnote here, guys, listened to Miss Sloane's phone calls in violation of California's wiretapping statute. Amazingly, 2 sentences later, the Sloane parties acknowledge that they lack knowledge about whether the Daily Mail or Nathan added the other to a private conversation without Miss Sloane's consent. In other words, the Sloane parties have no knowledge that Nathan did anything inappropriate. In any event, and putting aside the recklessness of the allegations, the conduct described by the Sloane parties does not constitute wiretapping under the cited statute. All right. The amended complaint also alleges that the Sloane parties made one or more statements to third parties, including to the New York Times, to the effect that the Wayfarer parties engaged in, permitted, and or failed to prevent sexually inappropriate conduct towards Lively and others, and retaliated against Lively for reporting the alleged sexual misconduct, including by propagating false narratives about Lively for the purpose of damaging her image and reputation. The pleading alleges that the Sloane parties told the New York Times a false and damning story about an insidious PR sabotage operation deployed as revenge for sexual harassment complaints, with the knowledge and intent that the newspaper would publish the false story, and that the Sloane parties propounded a false smear campaign narrative designed to destroy the Wayfarer parties. One second. Okay, now we're going to get to the specific questions here. Interrogatory number 3 is overly broad. Number 3 requests, identify each person you allege the Sloane parties communicated with regarding the Wayfarer parties. As set forth in the Wayfarer parties' formal responses and objections, this interrogatory is not limited to matter, not limited to matter that is relevant to any party's claim or defense. The Sloane parties contend that the relevance of this interrogatory is obvious, given that the Wayfarer parties are asserting claims for defamation and false light based upon unidentified conversations Ms. Sloane allegedly had with unidentified persons at unidentified time using unidentified words. However, the interrogatory is not limited to identifying the names of witnesses with knowledge of information relevant to the subject matter of the action, as required by Local Civil Rule 33.3a. The Sloane parties conceded that interrogatory number 3 is overly broad, and they narrowed it to only seek the identification of people with whom they communicated to the extent those communications are relevant to the claims and defenses in this action. However, the Wayfarer parties responded to a different interrogatory seeking broader information. Interrogatory number 1 requests the identification of any person believed or known by you to have any information or knowledge concerning any event, fact, matter, act, allegation, or issue included in or raised by the complaint or amended complaint you filed in docket number 25. Okay, let me unpack that for a second because that was wordy. So they responded to an interrogatory that was seeking broader information. Okay. Identification of any person believed or known by you to have any information or knowledge concerning any event, fact, matter, act, allegation, or issue. Is that only regarding people that were on the set? Or is that just like everybody? Because that's... Okay. In response, the Wayfarer parties incorporated by reference their initial disclosures, which the Sloane parties admit disclosed over 150 individuals and entities. Okay. That's a lot. Well, I mean, it sounds like a lot to me. I don't know if it's a lot for a case like this. You know what I mean? All right. Contrary to Sloane parties' contention, the Wayfarer parties did not waive their Local Civil Rule 33.3a objection to interrogatory number 3, and cases cited by the Sloane parties for that proposition are easily distinguished. All right. Normally, I skim over this case law stuff, but it doesn't look like there's too much here. In codename Enterprise Incorporated versus Fremantle Media North America Incorporated, let's see. The court held that the plaintiff waived its Rule 33.3 based objection because it never mentioned Local Civil Rule 33.3 specifically and failed to explain why each of the interrogatories was objectionable under that rule. Okay. Here, the Wayfarer party's general objections, which are expressly incorporated into each specific response, objects to each interrogatory to the extent that it exceeds the scope of interrogatories set forth in Local Civil Rule 33.3a. Additionally, the Wayfarer party's specific response to interrogatory number 3 explains that it is objectionable because it broadly seeks the identification of anyone with whom the Sloane parties communicated regarding the Wayfarer parties. As for Freeman versus Giuliani, the defendant therein violated the court's order by failing to respond to interrogatories by a specific date, which certainly is not the case here. All right. Hey, mods, I see people popping in here. Thanks for joining. Appreciate it. Okay. Allison was a good actress. Who's Allison? Sorry, I'm confused. All right. Interrogatories number 4, 5, and 7 are improper. Numbers 4, 5, and 7 seek the identification of A, each alleged defamatory statement, B, each malicious story portraying Baldoni as a sexual predator, and C, each of the stories critical of Baldoni. These are impermissible contention interrogatories that exceed the scope of local civil rule 33.3. In their plea for leave to exceed local rule 33.3a, the Sloane parties disingenuously contend that they need a basic roadmap of the claims against them to prepare their defense. However, as detailed above, the amended complaint specifies the media outlets with whom Sloane conversed, approximately when she spoke to them and the words she used during those conversations, to the extent that the Wayfair parties have specific knowledge of facts relating to her defamatory statements. If Miss Sloane engaged in other defamatory conduct, she will not need to guess which of those are defamatory, because she is the one who made the statements. As for her need for the news articles that the Wayfair parties allege are defamatory or otherwise actionable, she will obtain them in document discovery. Request for production number 32 is improper. Request number 32 seeks documents upon which the Wayfair parties intend to rely in drafting a further amended complaint, i.e. a second amended complaint that does not exist, may never exist, and of course has not been filed. In response, the Wayfair parties objected on the grounds that the request seeks information protected from disclosure by the attorney-client privilege, work product doctrine, and any other applicable privilege. The Wayfair parties further objected to the request as premature because a second amended complaint does not exist. The case cited by the Sloane party stands for the unremarkable proposition that a party must produce documents referenced in its pleadings. If a second amended complaint is filed, the Wayfair parties will produce all non-privileged documents relevant to the claims therein, located upon a diligent search, to the extent that such documents have not theretofore been produced, including any documents referenced in such currently non-existent pleading. We respectfully request that the court deny the Sloane party's motion to compel. Unfortunately, Sloane party's true purpose in filing the motion is not to compel discovery, but rather to re-argue their, I don't know how you pronounce this, sub judice, is that right? Motion to dismiss, which they anticipate will be denied based upon the court's denial of their motion to stay discovery pending their dismissal motion. As you guys know, none of those motions to dismiss have been ruled on yet. In fact, the only motions to dismiss that we have seen ruled on were actually just like technicalities. If an amended complaint or an amended counterclaim or something like that was filed, it just rendered the initial motion to dismiss moot. It just means basically they're kind of hitting the reset. So they have to put in a new motion to dismiss the new complaint that's been amended. So it doesn't really mean anything. It could take months for the judge to rule on these things, so yeah, it's going to be a while. And that makes sense. He should be thorough, and also judges have a lot of cases on their plate. He's definitely not just dealing with this case, so, you know. Okay. Oh, right. Thanks, Michelle. Yeah, I'm trying to post on TikTok now, but I'm not very good at TikTok. And also, TikTok is just, I'm not there. I don't want to say they're not my crowd, because it's not like I don't like them. It's just that I'm not everyone's cup of tea on there. So, you know, it's hard, but that's all right. Okay, so like I said, I have another video coming out. Actually, you know what? Let me just post it right now, man. How about that? Link in new tab. That way I can just send you guys over to it. Content. I can set it to Premiere so there can be a live chat. Let's go 1250. Okay. What? No, I didn't mean to do that. How do I edit the setup? Classic. Do 3 minutes. Okay. Sorry, guys. Just give me 1 sec. And if any more documents come up, I'll do another live stream, but I don't see anything else at the moment. Okay, so I'm sending you here to this video that's coming out in a couple minutes. I just set it to 12:50. The live chat will open up so you guys can talk or whatever you want to do until it starts. And if you could hit the like on this video and that one, it really helps my channel out with exposure and all that. So I appreciate it. I'll see you guys shortly. Bye.